Hello and welcome to Connected with Latham, where we discuss ideas, legal developments and business trends shaping the global economy. I'm Anne Mainwaring, London Associate in Latham's Financial Regulation Practice. And in this episode today, we're talking about Brexit. In particular, the expectations on financial services firms in the run-up to, as well as beyond, the end of the transition period. And to discuss this topic today, I am delighted to be joined by Stephen Hanks, who is a manager in the Markets Policy Division at the Financial Conduct Authority. Stephen, welcome and thank you so much for joining me today to discuss this topic.
Good afternoon, and thank you very much for inviting me on to talk about Brexit.
So jumping straight into the discussion, and of course the end of the transition period is very much looming at the end of this year, and with 2 months to go, the number one question that I am being asked at the moment is, what do firms need to do between now and the end of the year in order to prepare for the transition period ending?
I think the things that firms need to be thinking about were set out fairly well in the Dear CEO letter from FCA and PRA on Brexit earlier this month. There were a number of things in that that we particularly highlighted. Firstly, the need for firms to have in place appropriate arrangements for business and contract continuity to make sure that they have spoken to clients and put clients on the right terms of business with the right entities. Secondly, that they've dealt with the possibility of the absence of a data adequacy decision by the EU, which means putting in certain standard contractual clauses to contracts with clients. Thirdly, that they've been thinking about preparations for the share trading obligation and the derivatives trading obligation. Firms need to be prepared for a range of scenarios here and able to deal with their clients appropriately in each of the potential different scenarios. Fourthly, there's an issue around the fact that at the moment firms will be using, or some of the vendors they use will be using, ESMA data systems, particularly the ESMA reference data and the ESMA transparency data system. And at the end of the year, there will not only be ESMA systems, there will be FCA systems in those areas. So firms need to be prepared and understand what the change to having two sets of those systems involve, and have spoken appropriately to the vendors from whom they take data for the purposes of transaction reporting and transparency. And then finally, I think the area that is most complicated is probably for EU firms who are going to be coming into the temporary permission regime. That's probably where there is the most significant changes in obligations. In particular, branches of EU firms in the TPR will need to be preparing for transaction reporting, not just to their home competent authority, but also to us, the FCA, and have been doing the necessary work to connect or to work with an approved reporting mechanism to report transactions to us.
Yeah, so that's really, really helpful. And as you say, there have been a number of helpful publications coming out from the regulators. And I think firms' thoughts are very much not just only thinking about the run-up, but also what's going to happen on what I'll refer to as day one, once the transition period ends. And I know that there has been this concept of forbearance discussed. And I was wondering if you could explain to us a little bit, what does forbearance actually mean in practice?
Forbearance isn't a word that regulators particularly like, but I think there are really three levels to this. If you look at the statement that we at the FCA put out about our use of temporary transitional powers, the so-called TTP, we highlighted a list of areas where we would expect firms to have made all reasonable efforts to comply by the end of the year. In respect of MiFID, the area that was called out in that respect was transaction reporting. And that, I think, mainly affects branches of TPR firms who, as said previously, will need to start transaction reporting to us and therefore have put the arrangements in place. It also potentially affects trading venues where they have EU members who do not have a branch inside the TPR and are trading from the EU. They will need to transaction report on behalf of those entities to us. Then there are areas which are covered by the TTP. Again, in MiFID, a particular area that is covered is trade reporting, where firms do not need to make changes to comply before the 31st of March 2022. They need to have made the changes by that date. They can make them earlier if they want, but they are given that grace period. In respect of trade reporting, it means that where you're dealing OTC with a EU counterparty, you don't need to report that transaction where you're not currently reporting the transaction. The third bucket is then effectively everything else. They haven't been called out as a priority area for compliance. They're not covered by the TTP explicitly. But what we have said there is that, again, firms need to make sure that by 31st of March 2022, they are complying with all of those obligations. But in the period between the end of this year and the end of March 2022, they need to look at those obligations, and we might have concerns if they are not doing something that we think would cause significant harm, either to consumers or to the market more generally. We haven't identified a list of potential concerns in relation to that, but firms do need to go through a process of thinking, are there any issues here where by not complying with the onshore regulations we could cause harm or not?
That's a helpful test for firms to apply as well. And going back to your point around the areas that have been called out by the FCA in terms of whether or not the temporary transitional relief applies, I know that there is this specific list, and is the best way for firms to view this as a hierarchy, or can they take it as a exhaustive list as their day one obligations? Because I know there are the more detailed directions which sit underneath those.
Well, I think what the detailed directions do is provide the absolute detail on where the TTP applies, and therefore where you are certain that we will not take enforcement action where there is some kind of differential between the standard that applies currently and the standard that will apply after the end of the transition period. So that provides you with certainty. In relation to everything else that is not covered by the TTP directions, then, as I say, there is a general presumption that you can take your time to the end of March 2022 to make sure you're fully complying with the new obligations. But you do need to do this sort of override check of, if I didn't do something, do I think it would cause significant and foreseeable harm?
And you've already mentioned that it's a bit too early to tell specifically what the regulator will be looking for. But is it right to say that there will be a formal piece of work to consider how firms have adapted post either the end of the transition and or the end of March 2022?
I don't think there's going to be necessarily a specific all-encompassing piece of work looking at what firms have done. I think it's more going to be a continuation of the way in which we typically work, which is doing pieces of thematic work on particular subjects. And part of what we look at when looking at a particular subject, and partly what might help to decide the sort of subjects we choose to look at, is whether there is a specific Brexit angle here where there's been some kind of change, which means, it's particularly something we need to focus on. Obviously, I said, transaction reporting is something where there is, it's not inside the TPR, and it's something people have to make all reasonable efforts to comply with by the end of the year. I would expect, next year for my colleagues in markets reporting to be looking at issues raised by the need to comply with the transaction reporting regime.
And I don't want to mention the word forbearance again because we agreed we didn't like it, but I sort of saw some parallels here between MiFID implementation and some of the messages at the time. So, if a firm has got proper plans in place and they've lined everything up appropriately, but they experience some teething issues, whilst I expect they would have to back report, would forbearance mean there is some flexibility there, obviously subject to specifics?
The difficulty around the word forbearance, but clearly we are a pragmatic regulator, and the test for us, as I think the TTP statement sets out, is we have a statement about our approach to enforcement. So for obligations which we have said we want people to comply with by the end of this year, it is the standard tests for whether or not we would take an enforcement case that will apply next year. I think if you look at the history of enforcement activity, what we have focused on is significant instances where firms have failed to comply with their obligations. It's not generally a case that we are taking, we're finding people where there has been some small imperfection with what they've done. So it's not that we are tolerant of that. We want firms to comply with their obligations, and we will take often action, supervisory action, which falls short of enforcement action to ensure that they are doing things properly. But we are not going to be taking action, partly because we don't have the resource, against each and every failure to meet our regulatory obligations.
Again, it's another question that comes up all the time. Does a Brexit deal, which covers financial services, make any difference to this or the regulator's approach?
Well, obviously, from the UK government's point of view, and also what was covered in their political declaration about the negotiations on the free trade agreement, the focus in financial services was really about equivalence. So, the ability in MiFID terms for UK and EU firms to use each other's venues for the purposes of the share and derivatives trading obligation, and equivalence for investment firms to be able to provide services on a cross-border basis into each other's jurisdictions. Obviously, the Commission has said quite clearly that it is not expecting to grant equivalence for investment firms, but I don't think this, fundamentally changes what firms are going to be having to do. Clearly, it is helpful if there's greater freedom to provide services on a cross-border basis, but still, I would expect that firms will want a presence in each other's markets if they're wanting to do significant business in that market. So you would still expect, UK firms to be setting up, as they have done, subsidiaries in the EU, and EU firms to be looking for authorisation in the UK, and firstly via the temporary permission regime. So, if there was a deal along the lines envisaged in the political declaration, it would make some difference, but I don't think it's going to. Passporting as we currently know it is no longer going to exist, whatever the outcome of the negotiations.
And it's my understanding it's not the case the onshoring changes would also be swept away or something. They'll still be relevant either way, essentially.
No, clearly we're still going to be outside of the EU, outside of the single market. We will need our own regulatory regime. And also, clearly, UK authorities have made clear that when it comes to equivalence, we see equivalence as a matter of equivalence of outcomes rather than simply a line-by-line equivalence, and something which doesn't involve the UK as being simply a rule taker from the EU.
And this probably leads us on nicely to look in a little bit more depth of some of the key issues coming out of the onshoring exercise and the impacts that they will have for firms in practice. And I wanted to kick off by talking about a point that you have already raised, which is the derivatives trading obligation. I just wanted to check on that in terms of scope. So where you've got an EU firm with a UK branch, be it sort of with its own authorization or through the temporary permission regime, will that branch be regarded as a third country entity rather than a financial or non-financial counterparty in scope of the derivatives trading obligation post the end of the transition?
The way in which we have onshored, and consistent with the treatment of existing third country firms who are authorised in the UK, is that they will be treated as a financial counterparty for the purposes of the UK derivatives trading obligation and not as a third country entity.
Thanks, Stephen. That's really, really helpful. And another area that you have mentioned, we've already talked about as being key, is transaction reporting. And you started us off talking about the particular impact for branches and the need to make sure that firms are operationally ready for that and the potential for double reporting. The other thing I also wanted to ask about are the changes relevant to all firms that will be subject to the UK transaction reporting regime as a result of the way that RTS 22 and the amendments that are being made to the reporting fields. So, I mean, clearly firms need to make sure that they are adjusted to these amendments and that they will be reporting according to the UK regime. But are there any particular changes that you see as having a more significant effect for firms in practice? Because I know that a lot of the changes are consequential in nature. So, changing definitions to include the UK, etc.
In terms of transaction reporting, if you are a UK firm currently subject to the transaction reporting obligations, you should notice very little difference in January than from the current state of the world, because the scope of transaction reporting, as with the scope of the market abuse regime in the UK, is not going to be limited just to instruments which are traded on UK markets and instruments related to those, but will have a wider scope and take account of instruments traded on EU venues and instruments related to those. That was to ensure, because UK firms obviously do a lot of trading in the EU, that we can continue to ensure market integrity across a wide range of activities by UK firms. So in terms of the trades that you have to report, they should be a similar set of trades that are going to have to be reported in January as you currently have to report today. And most of the other changes, I think, are relatively minor. There was an issue around identification of natural persons and whether or not which way of identifying natural persons you follow, particularly where they were dual UK and other nationalities, where in the process of onshoring, we put forward one proposal which would have changed the status quo for dual nationals with a UK passport. We backed away from that in the final set of rules.
So the status quo has been maintained?
Yes.
And then I think that probably leads us on to what I see as being one of the most significant changes to the MiFID II regime as a result of the onshoring, which is the changes that are being made to the transparency regime.
Yes. I mean, we published a couple of statements in the run-up to Brexit deadlines last year, I think one in March and one in October, on how we expected the transparency regime to work in the event of a hard Brexit. And we would expect to update that statement probably next month. I can't tell you exactly what the statement is going to say, but clearly it's going to share a number of similarities with what we have said previously. Moving from the end of this year into immediately into next year, the sort of day one as you characterised it, you shouldn't notice a huge amount of change. We will have the same transparency thresholds as currently apply whilst we're inside the single market. Change in this area will build up gradually. There is the potential for instruments which are newly admitted to trading after the 1st of January, particularly equities, to end up in different transparency buckets, both here and in the EU, depending on different levels of trading. We also have to make a series of decisions about what we do during the course of the year, where if we simply crank the handle on the calculations using the methodology in the technical standards, which is identical to the methodology in the technical standards in the EU, but using UK-only data whilst the EU is using EU data, you will get, again, different results for the same instruments. I think it's a particular issue in relation to bond trading. So we will have to think what we're going to do in terms of the quarterly determination of bond liquidity and also the annual calculations of the bond transparency thresholds, because we will have a situation where a lot of the same instruments will be traded here and in the EU. A lot of the bond platforms are going to have subsidiaries in the EU trading exactly the same instruments as they offer on their UK platforms, and clearly differences in transparency thresholds and liquidity determinations could move business between the UK and the EU. So that is something we need to talk to market participants about, and we'll be doing so relatively soon in order to come to a decision as to what we want to do in the course of next year.
So is it right to then characterise this at the wider level to say that the ultimate policy aim is to, as far as possible, maintain the status quo?
It's not really maintaining this status quo as such. Clearly, there are going to be two separate transparency regimes. Also, we would expect the current pattern of trading between trading on venues in the UK and trading on venues in the EU to change, particularly if there is no mutual equivalence for the purposes of the share trading obligation and derivatives trading obligation. So there are reasons why it might be sensible in relation to particular instruments to have different transparency regimes, in relation to an instrument to have a different transparency regimes in the two jurisdictions. But we need to sit down and think about the consequences about that and what, if anything, using the temporary powers that the Treasury granted us in relation to the transparency regime, we want to do to produce outcomes which make sense from the overall perspective of the market. But I think, and again, this goes back to your early point about the agreement not necessarily having huge consequences in certain areas. There is nothing in the sense of the things that were being on the table in terms of the political declaration which talked about UK and EU sharing data for the purposes of the transparency regime. And whilst clearly we have the power to share data and take account of it in our calculations, EU legislation doesn't permit ESMA to do that. It tells it only to look at EU data.
Yeah, understood. In terms of firms reacting to this, I assume, there'll be a bit of an understanding that there will be a ramp up period, and it's just a slightly different approach or a different approach to what we are used to. Again, is that something where there will be quite a bit of communication with firms?
Well, as I said, we're going to put out a revised supervisory statement. There's going to be more details. I mentioned FCA versions of FIRS and FITTERS, the two systems that ESMA runs in relation to transparency and transaction reporting. We're currently doing parallel runs of the UK systems for people to get used to them, but there'll be more information about how the cutover will actually happen. And then, as I say, because you have various calculations in the transparency regime staggered through the year, there will have to be further communication about what is going to occur around those calculations.
Thanks, Stephen. And finally, sort of walking through some of these key changes. Again, it's an area you've already mentioned, but I just wanted to come back to post-trade transparency. And you've said that the general relief applies here. And that's why I wanted to flag this, because I see it as a sort of out of the MiFID provisions that are being onshored. Again, the reporting position is maintained if you are transacting with an EU investment firm and you wouldn't currently report. Will that be the case, for example, for a UK branch of an EU firm, or will there be a difference there? And again, does the temporary permissions regime play into that?
Well, it begins to get complicated for branches of EU firms, because clearly, if you read the ESMA Q&A, they are also subject to the EU transparency regime. And in the run-up to previous Brexit deadlines, ESMA made clear that those firms, whenever they transact with an EU, with a UK firm, regardless of whether the UK firm has to report under our regime, they would have to report in the EU if it's an instrument which is traded on a trading venue in the EU. But I think at the moment, if the branch is not reporting a trade which it does with an EU counterparty, either because the EU counterparty is the seller of the trade or is a systematic internalizer in the instrument, they will not have to report that trade as of the 1st of January until the TTP unwinds. Where there is more of an issue is that clearly there will be some instruments in the UK which are not TOTV in the EU, and where that the UK firm may be the either the seller of the branch of the EU firm may either be the seller of the instrument or a systematic internalizer, and they will need to report those instruments.
And then on the free trade transparency side, is there a similar position here?
Well, I think for instruments which are traded both here and in the EU, if you are a TPR firm, then substituted compliance kicks in, and you can discharge your obligations in the UK for instruments which are liquid in both areas through compliance with your obligations in the EU. Again, I think there is more of an issue around instruments which are not TOTV in the EU, but are traded on a trading venue in the UK and are deemed to be liquid. Then in those circumstances, you will have to, if you're a systematic internalizer, be trade transparent in the UK.
And another area I wanted to ask you about is the in-flight legislation. So, moving out of the MiFID-specific sphere, there is a body of legislation coming from the EU, which isn't yet in force and effect in the UK. And again, the area I'm asked about all the time are the ESG reforms coming down the track from the EU. Again, is there anything or any update that you're able to share with us in relation to what's likely to happen with this legislation and what the approach is likely to be in the UK?
Well, I can't provide you with a specific update in relation to the ESG, other than to say, obviously, ESG is something which the FCA is very much concerned with. We publish various documents on it. And I would expect that we want to, look at the changes that the EU has made, and probably some of that will turn up in UK legislation. But it is a discretionary, or in UK rules, it is a discretionary decision as to what we do and also the way in which we do it. It might be that we take a look at what the EU has done and we want to do something similar, but we think that the EU, there's some of the detail that we think can be done differently without undermining the objective of what is trying to be achieved here.
Well, that as well leads nicely on to my last question, which is in relation to the UK, the FCA policy approach after the end of the transition period. And as you've already discussed, there will be discretionary decisions to be taken. But are you able to sort of comment on anything we're likely to see here? The thing I particularly had in mind is, for example, the MiFID quick fix changes that we are seeing going through at the moment. Is that something we're likely to see coming across into the UK? And then are there sort of any key areas where there might be a change in a supervisory approach, or, that the FCA has particular views on that you can share with us?
Well, I think the MiFID quick fix comes into the sort of in-flight type area that we were previously discussing. We are looking at what the EU is doing here, and I think quite a bit of it looks reasonably sensible. So that's something we need to think about in terms of potentially consulting on our own changes, because as I understand it at the moment, clearly a lot of what is in the quick fix from a MiFID perspective is a set of conduct changes which could be enacted through changes to the FCA handbook. So we need to consider whether we want to consult on a similar set of changes, but that would probably be next year. But I think more generally, obviously partly dependent on where the negotiations get to and where equivalence comes out, naturally, as the EU is doing on various areas, the UK will want to reflect on its regulatory regime and potentially to consult about changes. This is obviously, however, linked into the future regulatory framework. There was the second consultation document published earlier this week, in which the Treasury is saying that a lot of European obligations have been onshored into legislation, but it wants to pass the ability to make rules in those areas back to the regulators rather than have it in legislation, but subject to a slightly different framework to the framework that prevailed when FSMA was first introduced back in 2001, 2002, with more sort of accountability to Parliament and more direction by Parliament about what it wants the regulators to do in the rules. Now, to deliver on that will require primary legislation, and the timing of that primary legislation is currently uncertain. So we don't know when we are going to get the powers to look at areas where we could then look at both the level 1 and the level 2 of particular pieces of legislation. I'm sure that, talking with Treasury, there'll be things we want to consult on before the FRF is legislated for, so that we are prepared for the changes that it brings. But I think, in essence, we're not necessarily always going to be thinking about issues in terms of the dossiers that we've inherited from the EU. Aspects of those dossiers, looking at things dossier by dossier, doesn't always produce the right results. Clearly, you have UCITS in AF&D. It might be better to look at the two of them together rather than as two separate dossiers. On the conduct area, we have insurance mediation legislation and MiFID and PRIPS all looking at a similar sort of area, and those could be looked at together rather than as simply separate dossiers. But this is again something that there will be more on in the course of next year. And I also think the EU has CMU, which is providing some kind of overall framework for the work that it's doing, looking at legislation at the moment. And I'm sure the UK will want to have some kind of framework, whether at Treasury level or at FCA or PRA level, which sets out, well, look, this is what we're trying to achieve by regulatory change. These are the sorts of things, therefore, the general principles that ought to guide us when making more detailed decisions.
Stephen, that has been incredibly useful. Thank you so much for talking us through that. I hope everyone listening finds it as helpful as I did. And thank you very much for your time today to join.
Well, thank you very much for inviting me on.
And thank you everyone for listening to this episode in our Connected with Latham podcast series. You can subscribe and listen to new and archived episodes of Latham's podcasts on lw.com, Apple Podcasts, Google Podcasts, Spotify, or anywhere else you listen to podcasts. If you'd like more information about the topics in this podcast, please email us from the links located in the show description, and we hope you'll join us again next time.
This podcast is provided as a service of Latham & Watkins LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins LLP, and you should not send confidential information to Latham & Watkins LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things, and you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins LLP, 885 3rd Avenue, New York, New York, 10022-4834. Phone number 1-212-906-1200.